Welcome back. We now move on to the second segment. Our next speaker, Ms. Jessica Shurson's topic is encrypted data. Any discussion about electronic evidence in the digital era must reference encryption. Criminal investigations may be frustrated by encryption, especially when encryption obscures the communications of criminal offenders. This presentation will discuss the encryption workarounds available to law enforcement, primarily under the laws of the UK and the US. Over to you, Jessica.
Thank you so much. Let me share my screen here. Just take one moment. All right. My name is Jessica Shurson, and I am a PhD candidate at Queen Mary in London, where I research digital access, law enforcement access, to digital evidence. And as of August 1st, I'll also be a lecturer in law at the University of Sussex. So just briefly today, we're going to discuss what encryption is. I don't want to spend a lot of time on that. I'm hopeful that everyone is fairly familiar with encryption. And then how law enforcement can gain access to data that is encrypted through compelled disclosure. This, of course, brings up the privilege against self-incrimination, which we'll discuss in several jurisdictions. And because it is difficult, as we will see, for law enforcement to compel disclosure of passwords and passcodes from suspects because of the problem of incriminating themselves. They don't want to give up those passwords and passcodes. We're seeing increasingly that governments are looking to compel service providers to provide them with access to encrypted data, and we'll discuss that just briefly as well at the end. So I can't go over everything in the chapter. Of course, the chapter goes into greater detail and depth, but I did want to just go over briefly what we mean by encryption. So I think, just to start, obviously encryption is the application of cryptography. Often in digital evidence, we're talking about the application of an algorithm that obscures what was readable data into unreadable data. And the way to make those unreadable data readable or intelligible again is through the use of an encryption key. So who has the keys, right? Where are the keys? If we're talking about an end-to-end encrypted messaging app like WhatsApp, for example, the keys are with the end users, but we don't actually physically go put in a key to unlock our messages. This all happens within the app running behind the scenes. There are, of course, places where we do enter keys into our devices, for example, to unlock a device and access data that is encrypted without that password. So I think the easiest way to discuss all of this is just to use an example. Let's say the police arrest a suspect on his way to work. He has a phone and a laptop in his possession. The police are suspect that this person has child sexual abuse material on the laptop, so photos or videos in a file on the laptop that would be evidence of this criminality. When the police arrest the suspect, they seize the devices and they go to open the laptop to find what they believe will be the files showing the sexual abuse materials. Well, when they go to open the laptop, of course, up pops a box that says you have to enter a password or a passcode in order to gain access to the files on the laptop. So we see this with devices, with our laptops, with phones, that most of these devices these days are encrypted by default. And so they have to be decrypted in order for police to gain access to the data on the device. So where are the keys? So the police basically need the key. That's what they need in order to gain access to the encrypted data. The keys first can be with the user. So the suspect himself should know the password to his laptop. This can be presumed by the fact that it was in his possession when he was arrested. But let's say that the police demand the suspect turns over the password and he refuses. Is there possibly a third party that the police can go to gain access to the encrypted data? If, for example, the suspect was on his way to work and this laptop is a work-issued laptop, then it might be possible that the police could go to an office manager or an IT person at the office where the suspect works, and they may be able to provide the password as well. Or who needs the keys, really, right? There might be situations where law enforcement are able to hack into the laptop or device, and we saw this happen with the FBI, which is in a famous case, which is detailed in the chapter, of a shooting that happened in San Bernardino, California several years ago. The shooter had an Apple iPhone that was passcode protected, and the police were unable to get into the phone. They tried to compel Apple to basically change the software on all iPhones. That's how they would have had to do it in order to break into the encrypted phone. Instead, they eventually, because Apple didn't cooperate, found an exploit from a hacker, I believe, in Australia, which they bought from the hacker, and they were able to get into the phone that way. So sometimes the police don't need keys, but most of what we're going to talk about today are when the police need a key and how do they get the key. They get the key by compelling disclosure. So the compelled disclosure laws in England and Wales are what we're going to focus on. The power is in the Regulation of Investigatory Powers Act 2000. And the legal process is called a Section 49 notice. This basically allows the police the power to access, quote, protected information. This would include encrypted data within it, either by requiring the disclosure of the data in readable form. So if our suspect has this laptop, they might not be able to compel the suspect to give them the key, but they may be able to compel the suspect to put the key into the laptop himself and then turn over the device, which is unlocked. So everything then on the device, all of that data is in readable form. Or this also includes the power to require disclosure of a means to access the data. So this would be turning over the passcode itself, either from the suspect or again from the office IT manager, who might also have the passcode. There's also a power to attach a secrecy provision. So let's back up. Let's say in this example that I've discussed about the suspect being arrested, let's say before he's arrested on his way to work, the police believe that there might be some incriminating information on his work computer. When the suspect isn't at work, they go and tell the IT manager that they want to access the suspect's computer. They give the IT manager a Section 49 notice, along with a search warrant for the computer itself. And the office IT manager then provides the passcode to his work computer. They can attach a secrecy provision to this, saying you cannot inform the suspect that we have given you this notice. And this would allow them, of course, to preserve the integrity of their investigation until they're ready to arrest the suspect. Might keep him from deleting further evidence and things like that. The Section 49 notice is issued by a judge, so there's prior independent authorization, and the judge has to have reasonable grounds to believe these conditions are met. I don't want to spend too much time going through them because you can read them in the book, but there is, of course, legal process involved. And the police have to show that there's not a reasonably practicable way to obtain the information, to obtain access to the encrypted data in any other way. There might be another way to do it, but they if it's not reasonably practicable, then they can have the Section 49 notice issued. Failure to comply with the Section 49 notice is a criminal offense. So our suspect is arrested with his laptop. The police then serve a Section 49 notice on the suspect saying, we want you to either enter the password into your laptop or give us the password for your laptop. If the suspect refuses, in addition to any criminal charges he may be facing for possession of the child sexual abuse materials, he's also now going to be facing a penalty for failure to comply with the Section 49 notice. There is a defense that it's not reasonably practicable to make the disclosure. The burden of proof is on the defendant in that situation. And it doesn't apply. The criminal offense doesn't apply if someone honestly forgets a password. So let's say that the police search the suspect's house and uncover old computers that they seize. If the person is able to show, if the suspect is able to show that he honestly can't remember the password for those old devices, then he would not be charged with the criminal offense. But he has to be able to show that there is an honestly forgotten password there. The penalty for this criminal offense is 2 or 5 years, depending on what the police believe the encrypted data contains. So for the 5-year enhanced sentence, the police only have to show reasonable belief that the encrypted data is either a threat to national security or contains child indecency materials. This is a fairly low threshold. And the reason for that is because failure to comply with the notice in a situation like this is considered a deliberate attempt to try and conceal evidence of criminality. So if the files or the data on the device that the police are seeking to decrypt did not have evidence of a threat to national security or child indecency materials, it's assumed that the person in receipt of the notice would want to enter their password to exonerate themselves from this threat of an enhanced sentence and of enhanced charges. So if they don't do that, then it's assumed that it's a deliberate attempt to conceal criminality of one of these 2 offenses. This brings up, of course, the privilege against self-incrimination. So if the police are telling the suspect with a Section 49 notice, you must enter the passcode into your laptop to unlock the device because we believe there's evidence of criminality on the device. And then the suspect enters the passcode, unlocks the device, and of course there is a file on the computer with child sexual abuse materials on it. The suspect has incriminated himself by showing that he has control over that device by entering the passcode. So defendants have argued that the Section 49 notice violates their privilege against self-incrimination because by entering the passcode into a device or for a file that is alleged to contain criminal information, they're admitting that they control the criminal information. Now, courts have not been receptive to this in England and Wales. Of course, whether the privilege applies depends on the case. It's a qualified right. And the Court of Appeals has said that if the key is held independent of the will of the suspect, then the privilege does not apply. So in the case in question, which is detailed further in the chapter, the court basically said, once this suspect that we're discussing, we'll stick with our hypothetical case here, creates the passcode for the laptop at an earlier time, that passcode or that key now exists independent of his will. If it's put into the computer, it either will or will not unlock the computer. It's a separate identifiable fact at that point. Another case in which the privilege would not apply is if the substantive offense does not rely on control. The possession of the key would not be incriminating. In other words, if the offense which the suspect is believed to have been committed does not involve control as an element of the data on the computer, then obviously there would be no evidence of criminality there. And so obviously it wouldn't invoke the privilege against self-incrimination. And English law recognizes that the privilege can be set aside by statute when it's proportionate. The statute has existed now in the books for a very long time. The Court of Appeals has said, of course, that passcodes already exist independent of the will of suspects. So it's pretty much settled law by this point, at least the authors of the chapter, myself, and the others are arguing that it's pretty much settled law at this point in England and Wales, that the privilege against self-incrimination does not apply. Now, this is different in the United States. So in the United States, courts can issue orders to enforce search and seizure orders, so they can require suspects by court order to comply with police demands to enter in passcodes or otherwise decrypt data. So it's not in a statute, it's just by court order in the US. Courts have agreed that this does, again, bring up the privilege against self-incrimination. This is in the Fifth Amendment to the US Constitution. And it turns on a couple of different issues. First, whether the compelled decryption is testimonial. And assuming that requiring a suspect to enter a passcode is testimonial, is the testimony a foregone conclusion? So what do I mean by this? It's generally recognized that an act of production is neither testimonial nor incriminating if it adds little or nothing to the sum total of the government's information. So in other words, if the police already know that the suspect knows the passcode, for example, to his laptop, then it's not going to show them anything new. They already know that the suspect has control of the laptop. So by entering a passcode, the suspect isn't now showing that he controls it. The police already knew he controlled the laptop. So it's not adding anything to the government's case against the suspect. If that is the case, if the government can show that it is a foregone conclusion, then it does not violate the privilege against self-incrimination. Courts in the US are split, though, on two primary issues. The first is, what must the foregone conclusion be? So for example, in our case with the suspect with the laptop, do the police just have to show that they know the suspect knows the passcode? That's the foregone conclusion. That's easy to show because the computer is in the suspect's possession. It might even be further easier to show because his name comes up when they open the laptop where the password it needs to be put in, or it's been assigned to him by his office, etc. So they already probably know that the suspect knows the passcode. But is that what they need to show, or do they need to show that they actually know what the content of the encrypted laptop contains? Because when the suspect enters his passcode, it shows he controls that laptop, right? That might be a foregone conclusion. But it might add a lot to the state's case against the suspect once he does that, because they might discover all of this evidence of criminality that they didn't know was there. If they couldn't prove that evidence of criminality in any other way, then the suspect has actually added a lot to the state's case by unlocking the laptop with passcode. Courts are split. The Third and Fourth Circuit courts of appeal have said that they only have to show the suspect knows the passcode. The 11th Circuit has said that the police have to show that they know what the content of the encrypted device contains. The courts are also split on what the burden of proof is. So what must the police show? Must they show the foregone conclusion by a reasonable doubt? Must they show clear and convincing evidence, a balance of probabilities? It's all over the place on that. So we may suspect that the US Supreme Court might weigh in on this in a few years. It's hard to say exactly. And also because we're moving away from passcodes in some sense, we haven't discussed this yet, but obviously our phones, our devices are unlocked more and more by biometric information. So either putting your thumb down on it to have your fingerprint open the phone, or a face scan. And courts in the US are mostly agreed, of course not completely agreed because that would be too easy, mostly agreed that the entering of biometric information is not in any way testimonial, and so the privilege against self-incrimination does not apply. It's the same thing as a suspect being fingerprinted upon arrest or having a photo taken upon arrest, and so they treat that information differently. Of course, passwords and passcodes are still going to be necessary for laptops and files and computers, but devices also show a lot to law enforcement. Law enforcement usually want into people's phones when they're arrested, and the biometrics are a much easier way for them to get that.
Jessica, I just want to interrupt to say you have 2 minutes.
Okay, thanks. And we do look at a couple of other jurisdictions in the chapter. I just want to highlight Belgium here. In Belgium, of course, the privilege against self-incrimination is also a qualified right, as it is in other jurisdictions we've discussed. And the court case that we discuss from Belgium looks much like the UK rule on this, that the privilege does not apply if the evidence exists independent of the will of the person who has knowledge of the passcode. And they go further to discuss why this is, because the purpose of the privilege against self-incrimination is to safeguard fair trial rights by excluding false statements made under duress. And so because that is the purpose, we can see that a passcode remains unchanged regardless of whether it's communicated. So there's no risk of unreliable evidence or an unfair trial in that situation. Now, as you might expect, the police find it difficult to compel suspects to turn over passcodes. What's adding 2 or 5 years on a sentence when you're already looking at, 10 years? But if you don't turn it over, you have a pretty good chance of beating your case because the police don't have access to all of this evidence, right? And the police obviously want access to evidence of criminality. They discuss this as the going dark problem, that because of encryption, they are no longer able to have access to files, data, communications, especially they focus on communications that they used to have in the pre-internet era. They used to be able to intercept phone calls and mail through the post, and they obviously don't have that ability anymore. And so they're increasingly asking service providers to implement new capabilities so that they can access encrypted data. This does go beyond asking service providers for a key. In some situations, they're asking service providers to create a new key, a master key, if you will, putting in a back door to the communications platforms and giving police a master key for that door. But this brings up, I don't have much time to get into it, but we don't talk about it a lot in the chapter, but I did want to highlight it, and we do discuss it near the end of the chapter, that this is an ongoing debate, and it really impacts not just a privacy versus security debate, but a security versus security debate, because obviously we all use encryption to protect ourselves, to protect banking, online transactions, communications as well, and criminals use it too to hide the evidence of their criminality. And so we want law enforcement to be able to access evidence of criminality, but we also don't want criminals to be able to turn around and use a key that they've hacked, this master key or backdoors that they've hacked, to then commit more crimes against regular people who use encryption for protection. So this is an ongoing debate, and yeah, stay tuned. I think there's going to be a lot of changes in the next few years. So thank you very much.
Thank you, Jessica. Next up is Dr. Nigel Wilson. The proof of electronic evidence does require careful consideration and updated training. Dr. Nigel Wilson will be discussing a proof of electronic evidence, talking about the challenges associated with proving a fact with electronic evidence, the need for accreditation and training of digital forensic experts, as well as the validation of technology systems, methodologies, and all that in 20 minutes. Over to you, Nigel.
Thank you very much. Can everyone hear me okay?
Yep.
I'm honoured to speak to you about Chapter 9 and the context of proof. And before I start, I'd like to acknowledge, in Australia we use an acknowledgement of country, that I'm joining you from the land of the Kaurna people, who are the traditional owners of the lands in the Adelaide and South Australia region. The chapter that is speaking to the topic of proof is the combined work of international authors across the globe: Andrew Sheldon, Hein Dries, Burkhard Schaefer, and Stephen Mason. And the observation that Professor Schaefer has already made made a reference to some work by William Twining, which I'm reminded of in this context and at this conference. And it was an observation which he made to this effect. He said, if one is sensitive to the different levels of relations and ordering, then a global perspective can serve as much to emphasize diversity and complexity as to simplify. Thinking globally at least sets a context for focusing at other levels. Adopting a global perspective highlights the need for adequate analytical concepts that can transcend different legal cultures and traditions. And we have just heard about various different perspectives across different countries in the last presentation. as a coincidental aside, it's actually 150 years to next month that the overland telegraph line connected South Australia from Adelaide to Darwin, and then through a submarine cable through to Java and Singapore to enable messages to return to the United Kingdom. And I'm mindful that the audience on this call does transcend the globe with the global perspectives that Professor Twining referred to. When it comes to the challenges of proof in the context of electronic evidence, it is the case that the many significant issues arise from the way in which electronic evidence is either handled or stored, accreditation in relation to digital forensics, and we've heard a little bit about that already, together with validation of technologies and systems, and the preservation and analysis of evidence are critical steps in investigations, particularly in the criminal context, as we've heard as well. The chapter in relation to proof also covers the topic of probative value of the evidence and describes in more detail than I'm going to be able to tonight, my time, to the challenges arising from automation and technology solutions. So the topics that I've addressed are really the elements of the plot to the chapter, which is chapter 9, but it'll be for the reader to identify those characters and subplots. And the chapter does go through various case studies and various case analyses, which illustrate some of the points which I'm going to expand on. So I'm hoping, if I can, to whet the appetite for the reader in the context of proof. Some time ago now, in the language of the law of evidence, Professor Wigmore emphasised the distinction between what was described as proof and what might be described as admissibility. And a lot of experience as lawyers in the context of the language and the learning regarding the law of evidence is very much dedicated to the law of admissibility. But the observation made in relation to proof, in the way in which Professor Wigmore described it, is that it's the process of contentious persuasion seeking to move the mind of the tribunal or the court. The observation that I would make in relation to that is that when we come to the context of admissibility, it was observed by Justice Stein, later Lord Stein, in one of the early IT cases involving criminal appeals prior to the commercial application of the internet taking hold, that the law of evidence must be adapted to the realities of contemporary business practice. In language which sounds dated now, it was explained that mainframe computers, mini computers, will play a pervasive role in our society. But the observation was made that often the only record of a transaction, which nobody can be expected to remember, will be in the memory of a computer. When it comes to some cautionary observations that I think are to be made regarding proof, and we make in the chapter, is that when proving a fact using electronic evidence, what an individual may witness on the output, such as the screen, is the result of multiple phases of digital processing and interpretation performed by software, and the risk is that any processing phase could be subject to error. Similarly, when specialist digital forensic software is used to preserve and present electronic evidence, it does so using programmatic interpretation of the bits and bytes it finds. And this can also be subject to error or wrongful assumption. And for these reasons, proof as it applies to electronic evidence requires more than simple reproduction of data. We've heard that observation already in this conference. The process of adducing evidence and determining proof relies on the systems used and the training experience of the people creating and using them. Both people and systems need to meet significant accreditation and demanding validation to demonstrate that such interpretation of data has been performed accurately. This is partly because of the unique nature of electronic evidence, its volatility and the capacity of it to be altered with ease, even by, as we've heard, the simple act of switching on or off a computer. One of the other issues in the context of proof is the issue regarding the discipline or science associated with those who profess expertise or are called to assist in cases in which digital forensics occupies a frontier both in the context of cases, but in the context of the science underpinning the evidence that is adduced. By their nature, investigations and examinations of electronic evidence are relatively new compared to earlier and more established forms of forensic analysis. Broadly speaking, electronic or digital evidence investigations are concerned with gathering, preserving, and analysis of digital data to provide evidence and intelligence to assist with criminal investigation, prosecutions, and with civil and regulatory matters and proceedings. And forensic analysis of electronic evidence draws from diverse disciplines, as we know and we've heard of, in the context of electronic and electrical engineering and computer science and their sub-disciplines as well. One aspect which I think is very important to mention is that we have seen and witnessed over time an explosion of scientific knowledge, not just in the technological area, but in the sciences over time in certainly in the last 150 years, which also needs to be borne in mind. When it is that we look at the process of acquiring, copying, and handling of electronic evidence, the observations that are made, for example, in guidelines such as the Association of Chief Police Officers, emphasise the need for access to be done by competent professionals, that the process itself doesn't change the data, and that there is an audit trail in relation to the processes that have been undertaken, and the persons in charge of any such investigations have overall responsibility for ensuring that the law and principles are adhered to. When we look at the environment of forensic triage, one observation we do make in the chapter is that it's not always the case that forensic triage is suitable. Users with the appropriate training must use it in conjunction with an appropriate risk assessment of whether or not it should be engaged and the steps that need to be taken. We've heard through this conference quite a bit about preservation and analysis, and these clearly are some of the key elements in relation to formal proof and effective proof, enabling the persuasive bar to be met, as I mentioned at the outset. For those professionals who are experienced in criminal matters, the concept of continuity of custody, also known as the chain of evidence, is well established. However, the continuity of custody in both civil and criminal matters should be considered very carefully with respect to electronic evidence. Some of the observations which I've always found very beneficial to reflect on in the context of digital evidence have also been made by those scholars and practitioners in the North American environment, sometimes known as the Sedona Conference, with emphasis on the volume and ease of replication of the evidence, its persistence, its dynamic nature, the existence of hidden metadata, which we've heard of in this conference, and the nature of the observation about hardware and software dependence and obsolescence. And with that also the mobility, portability, and searchability of the evidence itself. One of the final observations that we make in the chapter is in the context of the special category of online wealth forensics, as it might be called. And a number of speakers in the conference have spoken to the context of this in much more detail, but we do seek to address it in brief in the chapter in the context of cryptocurrencies in particular. In contrast to electronic money, where a database containing a ledger is typically stored with a service provider, cryptocurrencies make it possible to store values, as we've heard, in wallets that are hosted on software present on a computer system or device. A special property of these currencies is the cryptographic values, and the wallet can be copied in order to make it possible to spend the currency from either one of the copies made. And this, as the observation has already been made in this conference, complicates both search and seizure of this type of evidence. And in various ways, emphasis has been made by other speakers of the need for appropriate training. From a legal perspective, it's also the case that one aspect of this issue in the context of proof is that increasingly international standards are making frequent use of the reversal of the burden of proof to explain what's sometimes described as unexplained wealth. And there are cases where a predicate offence can be proven, in relation to unexplained wealth which is found to be present following a financial investigation. In such cases, the burden of proof regarding the title to such wealth can be shifted to the respondent. Finally, in the context of reporting, findings and conclusions made by the digital evidence professional need to be set out in detail in the report. And we've heard in the presentations in this conference much in relation to the context of experts and the roles that they play. I've always been strongly influenced by the words of Lord Justice Jacob in the Rockwater case in 2004, which is actually an intellectual property case, in which the observation was made about the function of the expert is to educate the court in the technology. They come as teachers, as makers of the mantle for the court to don, is the expression that's used. For that purpose, it was said, it doesn't matter what they do or do not approximate. For that purpose, it doesn't matter whether they do or do not approximate to the skilled person, it was said. What matters is how good they are at explaining things. And I think a number of the speakers have mentioned that issue in the context of experts, but I think it's also incumbent on us as practitioners and counsel to be sufficiently able to communicate and explain to the court in the context of proof in particular, but in all cases to discharge that persuasive burden as well as our professional obligations. One issue which I think is well worth bearing in mind as well is what might be seen as the contradictory or pushing back aspect of forensics and proof. It is the case that as with all fields of forensic analysis, computer forensics is part of a continuous race of catch up between investigators and criminals. Just as criminals quickly started to wear gloves once fingerprint evidence had reached the awareness of the wider public, computer criminals too have begun to use tools to hide or alter the traces of their activities. Anti-computer forensics has become the term for the possible countermeasures that criminals may take to prevent, delay or invalidate computer forensic efforts, a problem which is increasingly recognised by the research community, as has been mentioned by some of the speakers already. When it comes then to the final observations, which I'd like to make in this presentation, the widespread use of computers, the internet and mobile phones and smartphones means that most lawyers now have to deal with electronic evidence and have had to do so for many years in various ways. The increased use of specialised law enforcement capacities, the more traditional criminal justice system and the advanced security and intelligence capabilities has created a field which is, in the way we've heard of through this conference, in a state of flux. The weighing of the probative value of the evidence can be straightforward only in simple cases for which ample precedent and standards exist, but not otherwise where the parties challenge the data and innovative methods are in play. In these cases, the court often has to rely upon digital evidence professionals, and this implies the need for thorough analysis. An expression that I mentioned was used and adopted by Professor William Twining in the context of the global perspective. Likewise, cloud computing and trusted computing affect the way digital evidence professionals obtain evidence, which means that care needs to be taken about how such evidence is obtained, which will then be potentially the subject of cross-examination. In conclusion then, in response to these developments, anti-computer forensics, as I mentioned, have emerged over the last decade or so at least, and present a significant challenge. The conclusion that we draw in the chapter is that the chapter posits various principles and standards for handling and analysing electronic evidence, noting that technological advancements will undoubtedly create new challenges and conflicts for the process of collating, evaluating, and examining electronic evidence in a legal setting globally. Thank you very much.
Thank you, Nigel. Last but not least, we have our co-editors, Mr. Stephen Mason and Associate Professor Daniel Seng. They'll be speaking about presumptions. While there's general concern amongst judges, lawyers, and legal scholars that evidence in electronic form is not to be easily trusted, There is a presumption in England and Wales and in Singapore that when a computer is in order at the material time, the evidence that the computer produces may be trusted. But is this a good thing? So over to you, Stephen and Daniel.
Thank you, David. We've agreed that I will begin and then Daniel will take over from me. And Ifran is very kindly loading one or two of my slides onto the computer at the moment. I'm going to make three very short points. I'm not going to speak for very long because the meat of the topic is in chapter 5 and it's a very long chapter and I've done a lot of research in both technical and legal fields to get that chapter right. But first of all, for all of those people who are listening to us now, if you're Russian, there's one person that you should be very proud of, and that is Stanislav Petrov, who was Lieutenant Colonel in the Soviet Air Defense Forces. And in 1983, I think it was, he was alerted to an apparent fact that the Americans had launched a missile strike on the USSR. And this was absolutely impossible. As he knew from external sources, there was no degree of incongruity and difference between America and the USSR, and he couldn't understand why the computers were telling him that 5 or 6 missiles were on their way. And he refused to actually initiate the procedure to strike back. As he said to the German magazine Die Spiegel, apparently in 2010 in an interview, "We are wiser than the computers, we created them," is what is purported to have said. And this is the point I want to make actually in the preamble to the brief discussion of the presumption that computers are reliable. The reliable computers are, the hardware can be very reliable. So I've been attending to this on my smartphone, which is a very old one, 6SI. And in theory, it is actually very reliable. But you noticed as I started speaking, my screen went blank, and it might go blank again. And this is because of the software, which I'll explain next time it goes blank. But the point that Mr. Petrov is making, and I think we should understand, not only primarily as lawyers, but also across the board, is the difference between the reliability or the purported reliability and the interpretation. And both Luciana and Alison have looked at authenticity, and Nigel just looked at the sweeping topic of proof. And it's an absolute pleasure, Nigel, to hear somebody quote Professor Twining. I did the proof course with him on my LLM course 25 years ago. And he has a lot to say, and he is very underestimated in my view. In fact, the proof course required you to do a short course of statistics before he accepted you onto the course. And only about 8 or 9 of us actually attended that course. I understand his numbers are always very low because he required so much of you. And the problem we have as lawyers, or the legal profession, I should say, has globally, is this problem that you often hear and in writings, and I often get people submitting articles to me in the journal, that electronic evidence is easy to change and therefore not reliable. And yet, when it gets to legal proceedings, every single lawyer, every mouse and every judge and every little incumbent inside the court agrees with everything a court has to say, a computer has to say, or purportedly say, which is arrant nonsense. And it would be really good to see the end of this completely. So to jump quickly to my slides, if you would be so kind, Ifram, is to go on to into the first slide, where I indicate what the Law Commission did. So in 1997, it had become quite apparent in the UK that they wanted to get rid of the need for lots of evidence of the reliability of systems, although it was hardly reliability under Section 69 of the Police and Criminal Evidence Act. So the Law Commission commissioned a paper, and this paper in 1997, as you can see from the screen, suggested that Section 69 should be replaced, and you have the wording on the screen there. This actually included computers by default. So Ifram, if you would go on to the next one, please. When you assert something, you should actually produce evidence to prove it. And yet the Law Commission, if you read this paper very carefully, could not or did not provide any evidence of any description to prove their assertion was correct. Hence the beginning of the problems. And if you would go on again then, please, Ifran, thank you. This, I would say, although I'm very loose in my language here, directly led to the massive scandal, historically massive scandal in England and Wales and also Scotland, leading to the injustice of Bates and the Post Office Limited case, which I'm not going to discuss. There's a great deal of discussion of this in the book, but also we've published a number of articles which are all listed beyond this particular slide for you to read up. The point I want to make very shortly is that you cannot presume that computers are reliable. Having said that, there's one thing I am not saying for those people in England and Wales who may be tuned into this and who may be fearful that I am saying you have to prove every single item of evidence in order to have it admissible in legal proceedings. That is not what I'm saying. What is necessary is that if the party against whom the evidence is adduced is saying, actually, this is not quite right, as occurred in the Post Office case, then there should be a mechanism by which the person who is adducing the evidence should demonstrate its authenticity and the fact that it can be relied upon. I'm using terms very, very loosely, cognizant of the fact that Luciana and Alison have spoken much more in depth about authentication than is necessary for me to talk about here. I'm not going to go into this in any detail anymore, other than just to point out on the next slide, if you wouldn't mind, Ifran, thank you very much, that the point is errors in computer systems, especially of course software code, may not be readily apparent. So it is not always obvious that you have a problem with the software. This of course could cause the computer system to behave in different ways which are unexpected, and the effects of the bugs in the Post Office Horizon system were not readily observable or identifiable by the end user, which was one of the assertions made by the person, the barrister, prosecuting in this case. If you would then move on to the next one, thank you very much, Ifran. The consequence in this particular instance was that hundreds of postmasters and others were convicted, sentenced to terms of imprisonment, and in some cases had their property confiscated. Already, the appeal courts have quashed more than 70 convictions, but there's over 2,000 or 3,000, which is, you know, astonishing. What does that lead me to conclude, as somebody's been writing about this now for a long time? Well, Professor Hock Lai Ho, I hope I pronounced his name correct. Daniel, I'm sure you can correct me, who is a professor at NUS, wrote his PhD thesis up as a philosophy of law, a philosophy of evidence law, justice in the search of truth. And I read that book. And the point is, Professor Ho demonstrates that the finder of facts acts as a moral agent. And central to this is that findings by a court must be justifiable and meets the demands of rationality and ethics. And on page 49, he says, the court must not only find truth in order to reach a just outcome, it must also do justice in the course of ascertaining the truth. Now, this is giving me a brief opportunity to tell you what the problem with the smartphone is. There is no problem. The problem is with the software engineers who wrote the software for this program. You will see a blank screen where my face is. On my iPhone, it says, iPhone is not activated. Contact your network provider if this problem continues to occur. Well, the point is, this smartphone does not have a SIM card. And so the software engineers have said, this is a problem, but actually that's a lie. It is not a problem that there is no SIM card in this telephone. It's a lie to say there's a problem. It's more accurate to say this iPhone is not activated because it does not have a SIM card. And that illustrates neatly the point I'm trying to make. So Professor Lai Ho also said, the trial, or more specifically, the trial deliberation, seeks the truth. It seeks the truth by justified belief in the facts of the case. And finally, in the context of hearsay, which is important when it comes to electronic evidence, the trial may be seen as a process of acquiring a moral authority to insist that the person whose case is before the court accepts its decision. So if we are making an assumption that computers are reliable, this has to be altered. And this has to be taken into account. And I'm sure Daniel and I will discuss this after I've now signed off and hand over to Daniel after he's finished in the question and answer session. Education is absolutely crucial. But I will not do any more at the moment other than say my PowerPoint presentation will include a list of additional relevant materials which will be helpful. And in order to progress things further, I'll hand over to Daniel, who's got a lot more further and more interesting things to say about aspects of electronic evidence. So Daniel, I'll hand over to you.
Thank you so much, Stephen. I will just briefly sum up the issue from the point of Singapore law. As you heard from Stephen, the post office litigation was a real disaster, a real black watermark, if you like, a black mark on the annals of British justice, because of the failure on the part of the prosecuting barristers to take into account the fact that it was their inability to scrutinize the reliability of the post office's computer systems that gave rise to this series of prosecutions, which turned out to be persecutions, because even the post office itself acknowledged that these errors were caused by errors in programming the system, leading to the shortfalls of the accounts that gave rise to the more than 500 thousands, as you heard from Stephen, prosecutions that took place, leading to, as you also heard from Stephen, the subsequent quashing of many hundreds of convictions by the Court of Appeal. All these arose simply because, to amplify the point, again, the failure on the part of the defendant's lawyers to secure adequate electronic evidence that would prove, or to put it in a different way, that would enable them to get the post office to demonstrate that the system showed sufficient reliability and integrity. So essentially, this turned on the issue of the presumptions which the court relied on in establishing the case that because this is a system maintained by the post office, it had to be reliable, and therefore the accounting systems also had to be reliable, giving rise to the prosecutions. What is the position of the law in Singapore? Now, I wish to point out that the position in Singapore, on the face of it, looks the same as that in England, but if one examines the language behind the requisite provision, which is section 116A of the Singapore Evidence Act, one notes a very key and subtle difference. The provision itself states, unless evidence sufficient to raise doubt about the presumptions adduced, where a device or a process is one that, or is of a kind that, if properly used, ordinarily produces or accurately communicates an electronic record, the court shall presume that in producing or communicating that electronic record, the device or process produced or accurately communicated the electronic record. The key word here, the key words here are sufficient to raise doubt. Now, let me explain the significance behind this. The phraseology, sufficient to raise doubt, is to be contrasted with the phraseology in section 116A 2 and 3 that states, unless evidence to the contrary is adduced. Which brings me back to the point that Stephen and I made in our chapter in the book, that this is at best, the presumption that we talked about is at best an evidential presumption. In other words, it connotes the concept of an evidential burden in which the party cannot be required to produce more by way of evidence than one is in his or her position could be expected to produce. To put it into simple English, what it means, as the Law Commission itself explained in 1997, having come up with that presumption that on the face of it looks like a legal presumption, is that all that is required to refute the presumption of the reliability of the computer system is to point to some suggestion that the system is not working properly, for then evidence to be called by the party relying on the computer system to indeed prove that the system is working properly. This is the concept of an evidential burden triggered by the language in section 116A, sufficient to raise doubt. And this, of course, begs the question, how does one go about rebutting a presumption like this? This could be, for instance, by way of evidence of previous computer failures that could not be adequately explained, suggesting, for instance, coding bugs, errors, defects, manual overrides. And this raises the point that Stephen made, which is, I think, to be amplified again and again, that there are very, very few computer systems that have provably correct code. No matter how you think about it, computer code is one of the most complex systems ever engineered by human beings. And it's really difficult to prove that computer systems are operating properly and accurately all the time in all possible contexts. Taking into account the complexity of modern computer software that involves not just the code that you write, but also the code that you rely on, third-party code, and the interaction between all these different parts of the code that you have written and that you have not written, with different software components and hardware elements. This means that the entire establishment of a computer system is very complicated and is therefore prone to error. Therefore, it is wrong to presume that because computers are working part of the time in some contexts, that they'll work all the time in every single context. And this is what the presumption tries to do. It tries to strike a balance between requiring the proponent to prove every single element of a computer system that works properly and focusing the attention of the courts on those components that do not actually work. So I think the long and short of it is that we have to deal with the pervasive use of electronic evidence. But at the same time, the over-reliance on the presumptions to short-circuit the process of a careful examination of the evidence to figure out if there are problems with the system or if there are problems with the code, call for the courts and counsel to be aware of the limitations and the shortcomings of computer systems. And this is what we mentioned in our papers, that there has to be a more generous or tolerant discovery of disclosure rules to accommodate the relative opaqueness of computer systems, in particular AI systems, and the need for the legal profession to be exposed to this requirement that they be aware of the shortcomings of computer systems and acquire the necessary knowledge and expertise to deal with all these issues. And I think on that note, I'll wrap up this part of our presentation and open the floor to questions and answers. But before I do that, do you have anything to add, Stephen, to my discussion?
Yes. Very briefly, just to emphasize the education, as everybody's been saying. The Sally Clark case in England and Wales, which was the case that Lynn mentioned earlier, was the sudden death of a baby and statistics was used by somebody who was not qualified to use statistics to prove that the mother killed the baby. This was finally and subsequently demonstrated to be wrong. And everything was thrown at the person, in this case, a doctor and a professor who gave evidence on this occasion. But not a single word has been said, as in the Post Office Horizon case, of the failure, the horrendous failure of the legal profession, both the lawyers and the judges, to fail to deal with this adequately. And in the Sally Clark case, as much as in the post office cases, the failure of lawyers to understand the topics, and in the Sally Clark case of the statistics, the failure of barristers and solicitors to fully understand they had to get statisticians in to help them, advise them on what they were doing. And this is highly significant. And I think the law as it stands at the moment and the way lawyers interact with technology right now for their own benefit is one thing, but their failure, and highly significant failure, to educate themselves and also to educate judges in electronic evidence is a dismal reflection of a legal system, a legal education, not just in England and Wales, but across the globe. It is a global problem. And I'm hoping of the people that are listening to this now, together with those of us who are enthusiastic enough to be part of this text, that we try to address that issue now rather than another 10 or 20 years' time. Thanks, Daniel.
Thank you, Stephen. So on that note, let's open the floor to questions and answers. Maybe I should start off with a question from Peter Gutman, who asked, wasn't there a similar situation in the 1990s in the UK with phantom withdrawals from ATMs, where banks prosecuted their customers for fraud based on invalid or entirely missing evidence? It was surprising to see what looked like the same thing happening again with Horizon 20 years later. Perhaps Burkhard and Stephen may care to comment.
Yes. The answer is yes. It's dismal. I've got nothing to say other than it just makes you weep, totally weep. I have personally tried with 2 different universities in England to persuade the legal departments to speak to the digital forensic departments in order to start working together to teach law students aspects of electronic evidence, and in turn to obviously enlighten digital evidence professionals in the making to learn a little bit about the law. But neither university has responded at all to my attempts. You can see my grey hair and my lines on my face means that I'm coming to the end of this. And I quoted Bertolt Brecht in the book. I'll just get it, because it's highly relevant to my view, and I'm embarrassed to continue talking about this subject now. I say Bertolt Brecht, in one of his poems, says, "Anger, even at injustice, makes your voice hoarse." I say that in the preface. I quote it, and I'm just hoarse from speaking about this subject and getting angry about it. And I sincerely hope that our session today, which has been kindly organised by Daniel and David and organised by Joseph as well, will help change things. Sorry, Daniel, but you've heard all this before, I'm afraid, and so have you, Burkhard, as well.
One thing that also for me is interesting in that parallel that was just mentioned, in both cases, I think we find a particularly problematic conflation between victim status and investigator status. in a way we do not normally find, I think, in the field of evidence. All that evidence was generated first by the very post office that then started the legal process. And from the word go, I think prosecution and post office were way too close. Same with the banks. They control their banking systems. They are the only ones who have access to it. So I think this is one of the things that sets, again, I think electronic evidence often, not always, but often apart from other forms of evidence. It is collected in very, very complex architectures that reflect massive power imbalances. How do I prove anything in my banking if the bank has all the access to the system? How do I?
Yeah, that's a very good point, Burkhard, because if you've got the presumption there and you want to try and rebut that presumption, the onus is on you to then bring evidence. And you know, the poor people don't have the resources.
Exactly, and once you analyze it from a power imbalance structure, more sort of political science analysis, the presumption should have been the other way around. The presumption should have been with those who don't have the ability to prove, and then let those who can rebut the assumption because they have access to the data do the rebutting. Not the way it was working in this case. So this insensitivity to power imbalances, I think, is a real problem.
Yeah, this highlights the fundamental problem about disclosure or discovery, whatever you call it in your jurisdiction, and the failure of judges to understand this need to follow up and order more disclosure. For those people who are listening, there's a case in America called Bookout, Bookout, Bookout. Miss Bookout was injured when her car ran up to top speed, and it was a software code, according to the jury, that actually caused that to happen. And in that case, the judge ordered Toyota, who were the manufacturers of the car, to disclose the software code, and that's how the software code could be analyzed. It's a very rare case. It was a very rare order for disclosure, and in fact, the judge allowed me to publish that in our journal. And for those of people who are listening, you can actually find that ruling and that order actually on the journal website. And the problem with the post office case, if we take the case of Seema Misra, Seema Misra, whose transcript of her trial I published in a journal in 2015 with her agreement and the agreement of the judge. In fact, in the lead up to that trial, 2 separate judges were requested by the defense for further disclosure of the post office, and they refused. And the judge who actually undertook the trial was also asked twice on 2 separate occasions for further disclosure, and he refused it as well. Now, normally, you do not get the arguments for disclosure printed, published, and of course, you don't get the judgment by the judge, their decision as to why disclosure is refused. But generally speaking, judges tend to be very conservative in ordering disclosure, and one can argue in electronic evidence that is not, it is no longer something which actually they should be considering. They often consider the cost, and they also accept the arguments of the person who is being ordered to disclose the evidence, that it is disproportionate in terms of cost. But in the paper that we wrote in 2021, which we published in our journal about suggestions as to ameliorate this problem, cost is not an issue in most instances, or shouldn't be.
To get the discussion moving, I have a question for Jessica and Nigel, and the commonality between their presentations relates to the disproportionate role that is played by cloud service providers, the tech companies, in controlling a lot of infrastructure, which relates to both the ability to prove the records that they store, as well as the encrypted records based on their implementations of different types of encryption methodologies and processes that they maintain. So maybe in a few words from both of you, how easy or how difficult has it been to get these cloud service providers to cooperate with legal processes seeking to access information?
Might ask
Well,
them.
I think, oh, sorry.
Go ahead, Jessica.
I think broadly speaking, because most of my research is looking at law enforcement access to digital evidence from cloud service providers, whether encrypted or not. So broadly speaking, cloud service providers, I do think want to, I say cloud, any internet device manufacturers included, I do think they want to comply with law enforcement orders for data. It is very helpful to their business model if they come out as very privacy protective. We've seen Apple advertise itself that way, and many others. However, when the order actually comes in, most of the service providers are complying with it to the extent that they can. Now, of course, when I say to the extent that they can, that brings up encryption. And the service providers strongly want to have encryption for their products. Again, part of it is a privacy consideration, part of it's a security consideration, part of it's marketing. People want to use end-to-end encrypted messaging apps, and so the service providers will continue to offer that. But they make the argument, and I think it's not a bad one, that if they quit offering these services, the criminals that are using encrypted services to hide their criminality are just going to go find a different service that will offer strong encryption. And then regular people won't have access to, non-criminals won't have access to the encryption they need to keep them safe. So that's the source of the fight at this point. But we saw Apple just a couple of months ago was going to voluntarily begin scanning all iMessages for child sexual abuse materials. And there was a big pushback on that, because if they implement that kind of technology for that type of material, that type of technology can be used, of course, to police speech and free expression and things like that. And so Apple actually scrapped their plans. But now we have in the EU, they're attempting to now make this a law, a regulation in the EU to start scanning messages for child sexual abuse materials. So it's a constant struggle, I think. But in general, I think service providers do want to comply up to the point of removing encryption with law enforcement.
Nigel?
Thanks, Daniel. I think the other observation I would make is that, and this is certainly for another day, there is an interrelationship between the domestic or jurisdiction-based issues in the location where the information is being sought or data is being sought, and any international obligations that might arise. Those things give rise to different considerations. But the other aspect, which I think is important to bear in mind, is the link between those obligations which Jessica's spoken about regarding privacy, as well as compliance with obligations regarding cybersecurity. But I think in the time that we have available, that would be opening up something altogether for another day. But I'd just emphasize those two intersections in the context of the question that you've raised.
Thank you so much, Jessica. Thank you, Nigel. I think there is also this additional complexity relating to data localization rules, which you alluded to, privacy and security, and this whole issue about whether we have an overarching international framework for data protection. And the issues just escalate, as you can see, shade very easily from evidence to privacy to security, and there are many instances quite interchangeable and overlapping in nature. Stephen, any thoughts about how we as scholars and practitioners can help to educate the public about this, and then the legal profession in general, about this increasingly complex world in which we live in? And I'm quite sure maybe after what you've said, we can persuade you not to retire from the 5th edition. We can persuade you to continue with the 6th edition. Because the job is a never-ending one.
The job is a never-ending one. You have to speak to my wife about the 6th edition. In response to your first question, though, about how we can educate the public, you and I both know, and I think most of our authors know as well, that when LexisNexis decided no longer to publish the book from the 3rd edition onwards, we approached a number of publishers, and at the time, the Institute of Advanced Legal Studies and London University has started up the open source book project, which lent itself, we thought anyway, to giving people the opportunity of buying a physical copy of the book, but also have it obviously as open source, which meant that you had a free digital copy. Certainly, the fourth edition was widely distributed, many thousands of copies. The only problem is, I think, that it doesn't seem to be making much headway in understanding, in making the legal profession understand it has to change, which is desperately important, really, as a corollary to the ordinary people. I don't know if I told you this, but when I was beginning to think about having the whole project as open source, there are some universities in the United States of America that have produced entire books online without putting them into PDF as we've done here, and making it into a product which you can sell as a book, but they actually just put it online completely as if it's a Wikipedia article, and then it's constantly updated. That's another opportunity which I thought we might consider, but has never been taken up. The problem we have, of course, is that I do, when it comes to a long book, and Peter Gutman from New Zealand might be listening to us now. Peter, I haven't read your electronic version because it's so long. I do apologize. If it was in paper, I'd read it from cover to cover. And I think that's the problem that a lot of us have, is that they're still useful to be in paper versions. I did write a book on ATMs and banking about a decade ago. The publisher aimed it at members of the public, and I aimed it at members of the public to illustrate all the problems with banking, both using ATMs as well as online banking and other aspects of banking. It was priced at less than £20 sterling, and we got less than 100 sales of each edition. So I don't know how to answer your question, which is quite an important one. How do we influence, members of the public? One could try through the media, but the media has their own agenda, and it's very difficult to actually push anything with the media as well. So I'm at a loss. I'm just hoping that because of this event that you and David have run in Singapore, some of those listening might come forward to be quite helpful in moving the momentum forward, not just in our jurisdictions, but in other jurisdictions as well.
Right. Actually, that may be a good note to end this conference, which is also a book launch. I think on behalf of David, we at Trail would like to thank all the contributors to the electronic evidence book who have made this conference possible. Please thank Lynn, Burkhard, Luciana, Alison, Jessica, Nigel, and of course our indefatigable Stephen, whose work, the very first edition, has actually inspired all of us to contribute and continue moving forward with our contributions to move the project forward. For those of you who are online, our purpose is, if you have a look at this link, which I put up here, the QR code on the left takes you to the University of London's Pressers page, where you can download the book for free. This is the extent to which we feel as authors we have a role to play in contributing to the knowledge that all lawyers should have in this space. And if you'd like to support the publisher, not us, we're not getting any much by way of royalties, if any. I've not seen a single royalty check so far from the University of London Press. You may, if you like, use the special code EEES30 to get the soft or hardcover printed copy of the book on the same website using the link that I provided. And of course, if you find it helpful and you wish to cite it for legal proceedings, that would indeed be tremendously gratifying to all of us here who are contributing to this particular project. I also believe that the organizers trail will be making available the slides put up by the speakers on our website. So please click or please keep this link that you have on the right-hand side to gain access to copies of our slides after the event is over. So it is on that note that I'd like to thank everyone who has come for this conference. I hope you found it useful. There's certainly, as the speaker says, as this participant says, a lot of food for thought for lawyers. We'd like to think that this is but the start of a long conversation, which will make all of us be more aware of the complexity of the issues pertaining to electronic evidence, and certainly make all of us better lawyers in the process. So let's put our hands together to thank all our wonderful panelists and authors for contributing to this conference, and I hope to see you again at our next trail event. Thank you very much.